So now we're all recording. Just to very quickly introduce this meeting, this is a meeting with respect to the petition of Elon Weinreb from the Weinreb law firm PLLC, even though I am affiliated with NICLA as a co-chair. I do or I should say I'm bringing this petition and brought it out to the world regarding fair compensation for New York neutrals working in court-annexed mediation programs as a function of my firm, not necessarily specifically to do with NICLA, although I do have some people from NICLA along here, including my co-chair for the ADR committee, Chris Fladgate. With respect now also, there's Nelson. Very good. So I also have vice chair now with me, Nelson Tipkin, and I want to thank everybody for taking the time to come to this meeting. I see also we now are just about to get on Jeff Kitchaven from California. So when he comes on, I want to thank him as well. I'm just going to get straight to the point. The purpose of this meeting is ultimately to show some of the work and research that I've done regarding the issue of neutral compensation for those neutrals working as part of court-annexed programs, not necessarily with mediation, although it's primarily that. Target with respect to the petition is Part 146, so Supreme Court as well, Appellate Division, Second Department's mandatory mediation program, and the special masters there. All these programs have various time limits, and again, for those people who want to, haven't seen the petition, it's available on change.org. Change.org/NY-AR, all capitals, -compensation, and then that's the URL. Okay, so with that, and without further ado, as I said at the agenda, what I want to do very quickly is to start out, and again, welcome Jeff, thank you very much. I want to start out just by showing some of the aspects of this issue which I've realized from research in setting up a table of state statutes, which gives you a comparative picture. It's not completely done yet, but we certainly have enough to go with that as to the state of the law in other states as to how neutrals are being compensated. And then I'm going to open up the floor, to discussion here. And again, this meeting is being recorded, so we have it for all of various bar associations, organizations that we're part of. Hopefully, we have a lively discussion from that, and that's it. So I'm going to get started. So very quickly, just to go through that initial presentation, let me just ask everybody to put themselves on mute. All right,
Elon, could I ask, you said you were going to start with other states outside New York. Why not start with New York? And I'm aware of at least 4 or 5 different fee structures for mediation in the federal and state courts around here.
Right. But that's the thing. I'm specifically only dealing with the state courts if we have it right now. Federal courts I'll deal with is the baseline. And that's a good way to start out. So I'm going to do that just to start out to show where we are. That's actually on the table, though, itself. And I see Krista just came on. Krista Gottlieb, thank you very much. She's from the northern parts of the state, so she and also western. She's from Buffalo, so she can also tell us a little bit more about the districts other than the Eastern District, which, by the way, I already have in the table. I put that in. And by the way, newsflash for anybody who's been following the Eastern District, they are starting in light of the COVID-19 backlog. There we have John Kernan. Okay, very nice. They are starting in light of the COVID-19 backlog a program specifically to deal with trial-ready cases for mediation under their mediation rubric. So without further ado, I just want to ask everybody to mute yourselves while I give this short presentation. Thank you very much, except for obviously for me. And I will now share my screen to show you where we are. Okay. So we'll use somebody as the test case. Let's see, I see Marilyn. Marilyn, can you just nod to see that you see what I have in front of me? Excellent, okay. So we have over here, as I said in the notes to this table of state neutral compensation statutes where I've been developing, and a quick shout out to Federica Romanelli, the new NICLA Part 137 Fee Dispute Resolution Administrator. She helped provide the information for Alaska and Alabama, respectively, which just came in about a couple hours ago. Again, to discuss this issue of neutral compensation, why free time compensation systems are intrinsically problematic. That's where I come to this, and hopefully everybody saw this in the email from last night. I have updated the quick answers a little bit. My view on this, and the reason why I started the petition, is because the principles of effort justification, which basically means you get what you pay for from a psychological perspective, Gresham's law, which means that ultimately you're going to have lower cost labor or even no cost labor being preferred over high cost labor, Fairness and equity, generally speaking, and that comes in two flavors, as you'll see below. The potential for abuse and also the potential for the minimization of diversity, especially when it comes to non-lawyer mediators, and on the other end of the spectrum, the special masters and other appellate level mediators, because all of these dynamics come to, at least in my view, create a problem when you're dealing with free time. It hampers all of the ability for people who are diverse to climb up, as Jeff, and I'm glad that he's on here, as Jeff's pointed out in a lot of these articles. So very quickly, just to go through these general answers, and then Evan, I'm going to go back to New York to start out and show them where the states are and give you a comparative sense of the landscape. And from a psychology perspective, and you'll see here that I have one of Jeff's articles. This is sort of an old chronological arrangement. There's a principle called effort justification, which basically means that the more people put effort into something, or alternatively cost, the more they value something. So the person who is associated with this is Leon Festinger, right? And he did a classical experiment involving fraternity members who had been through different levels of hazing. I see, by the way, there are one or two people who are on the phone here, so this is why I'm reading this directly. I know people can read, obviously, but I just want to inform the people who are on phones they can hear this. The research in these experiments showed that the more vigorous the hazing, the greater the loyalty to the fraternity. When membership was more costly, it was more highly valued and respected. So effort justification shows why courts and litigators should want mediators to be fairly paid by their clients. Mediator's job is in material part to help lawyers break bad news to their clients, and it's the interest of courts and litigators who want cases to settle for the clients to believe what the mediator says. As a psychiatrist, Mark Goldstein, author of Get Out of Your Own Way, is another person supporting this idea of Leon Festinger. I should say the full title of his book, Get Out of Your Own Way, Overcoming Self-Defeating Behavior, explains it's just common sense that the more you pay for something, the more you value it, the more you pay, the wiser you want to feel for having paid it. If you're paying a large amount, something inside, you will very strongly believe that you are getting what's worth it. You want to feel that you spent your money wisely. So you attribute value to a service in direct proportion to what you have paid for it. And for those who studied psychology before, this theory of effort justification is based upon a larger set of principles known as cognitive dissonance. That essentially, when we have a disconnect between what we're expecting and a given outcome, we try to do what we can in order to ameliorate that disassociation or that disconnect and that contradiction. So that's the psychology perspective. Then we have, as I said before, something called Gresham's Law, and this is discussed in an article going back to 2005. Jeff's first article was in 2004, so now we move it into 2005. And a lot of this comes from our friends, by the way, in California. So I want to just give it a shout out to them. Thank you very much for all your contributions to this decades past, right? And you'll see that in this article, attorney Charles Parcell ends up discussing Gresham's Law. Very simple, bad money drives out the good. And throughout this article, and again, I can't read the entire thing, he goes through the history. If those people who are on the chart, by the way, I asked the question, why is it that apparently California's statutes allow for compensation at a certain rate, but then it seems to be reported that there are certain programs like Alameda County that end up giving free time for 2 hours? The answer is actually in this article. Right? If you go through the history of it, you'll see what ended up happening. But originally, California had compensation starting out at $150 per day. That was for arbitrators and mediators at the time, and that's actually in the chart, where we'll get to back later. Later on, they ran out of money, and that became to be a problem. So at the end of the day, what ended up happening is that there's a lot of mediation in California that was performed for free. Now we're going back to 2005. Just want to give some statistics over here. Mediators donate many thousands of hours each year. And again, this was written in 2005. So right now, this is probably much more. I don't know if Mr. Parcell has updated this or not. But again, this is the state of the facts in 2005. Of the 28,500 cases sent to mediation in 2004, 97% were done pro bono with the average of 3 hours. That works out at 85,500 hours, which is an aggregate of nearly 43 years worth of free service, making mediators proportionally by far the most prolific providers of professional pro bono services. Basically, Gresham's Law boils down to, if we have a system which ultimately rewards free work, and free hours, then people are just going to go according to that, and in conjunction with, or in combination with, the principle of effort justification, the mediation will effectively be devalued. That, of course, applies to the other dispute resolution modalities as well. Sometimes arbitration and mediations, you'll see from the statutes, are grouped together, and it goes both ways. All right. We then move to another point, which is essentially fairness. Now, I did put this up on the grid because, first of all, we don't have enough time. Second of all, there are people, as I thought, coming up by phone to play this entire video. But I do recommend it for those who attended Dan Weitz's training from OCA in neuroscience. He has a wonderful video regarding capuchin monkeys who were given two tasks, actually one task to perform, but they were given two different rewards for the compensation for the task. The task was essentially putting a stone in the hand of an observer, and one monkey was given a cucumber, the other one was given a grape. Apparently, in the primate world, the grape is worth much more in terms of taste than a cucumber. And you'll see the result if you watch this video. It's very informative. But what ends up happening is the monkey, when that monkey sees the other one getting the higher level of compensation in the form of the grape, becomes, let's just say, very disconcerted and almost aggressive at the time, showing us some aspect of just basic observations we are as human beings from an anthropology, I guess, point of view, or a biology point of view. That deals with the concept of fairness. Okay, so it's obvious that if we have certain people in certain locations, and this, but by reference to this meaning other states, we have somebody, let's say in Michigan or Kentucky, getting a certain amount of compensation relative to New York, where you're not getting anything, or we have to break your 2 hours or 3 hours, which you don't have to do in those other jurisdictions. Well, it does lead to, at least in certainly in some cases, sometimes the reaction you have with a capuchin monkey, although probably not as extreme. The next consideration of fairness that we have is in multi-party cases, and this is something I just thought of as I ended up compiling this for today's presentation, and that is what happens when we have a time limit, whether it be 90 minutes, 2 hours, 3 hours, whatever it's going to be, and we have a multi-party case. All right, it's just a question that we're going to throw out. How in any case where there are more than 4 parties, and I think that's the magic number, with diverse needs and interests, are we expected to fairly allocate all the free time amongst the parties? Very often we have the plaintiff or the appellant, if you're dealing with appellate level mediation, going first. Well, sometimes their presentations are extraordinarily intricate. And guess what? They make their presentation, they go out to, let's say, 80 minutes, and suddenly everybody else who has a 50 or 60 page brief is left with literally 2 minutes to make an entire presentation. It's just not going to work as a matter of math. So something to consider from a fairness perspective is a time restriction really fair to the parties, irrespective of the compensation. Because what ends up happening inevitably, as I explained in the petition page, is that people end up looking at the clock and they say, okay, 90 minutes is up, 3 hours is up, I'm going. And it just doesn't give everybody the right chance and the ability to do that. And then, of course, there are people who are willing, even with people willing to stay. Let's say you have an 8-party mediation, 6 are willing to stay and they're not tied to the clock, the 2 are tied to the clock. But if the 2 who are tied to the clock are essential to the discussion of the issues, well, then the 6 are stuck. And we have to understand how to deal with that particular consideration in a multi-party case if we're dealing with time. All right, next, the potential for mediator abuse. I'm going to bring a page here from, this is actually Jeff's colleague, and I believe also Simeon Baum's. It's not on today, which we were, but still I know that he's written along with Victoria Pinchon. That's her book, along with Joe Pasternak, but it's really more, she's the primary author in this. This is Success as a Mediator with Dummies. I mentioned this as a training session numerous times. Again, the similar story to what you had before in the Charles Parcell article that was talked about in Gresham's Law, goes through the history, ultimately, of what went on with the California courts. I'm not going to read all of that there, but you can see basically the common conception in the culture, and the culture of society was that mediation started to be viewed as something for free. All right, but the advice that Ms. Pinchon gives to up-and-coming mediators is pretty much point out it as a warning. There's a little bomb that she has next to it. That's the For Dummies logo. It's not, I don't think it's hers personally, but that's what they do in this series. But anything is a particular point of a warning. And again, coming at page 26 of the book, it's pretty early on. She writes, don't spend more than a year on one of these pro bono panels. You're referring to court-annexed mediation programs in your area. There's a sentence before. Otherwise, you may begin to feel used and abused. Again, possibly a reference to the Capuchin Monkey video. The attorneys in the mediations are all paid for their services, as is the staff of the court-annexed mediation program. The judges who order the cases are also paid, as are the court clerks and bailiffs who make their jury rooms available for you to mediate with the litigants. Although this is obviously pre-COVID, so now things are a little bit different. But she concludes with, you should get paid too. We then have an anecdote of mediator abuse, as she calls it, not my words, it's her words, from Phyllis Pollock, who, full disclosure, will be presenting with Jeff in a combined NYCLA Beverly Hills Bar Association comparative mediation practice seminar that we have coming up. But Phyllis writes of a story where she ended up mediating as part of a pro bono panel. And I'm not going to go through everything over here, but you can see this. It's up on the screen. And just for those people who want to see it later on in the recording, I just want to get to the main point where she talks about what happened at the end of her 3 hours. That was the time barrier there, 3 hours, which is the same, by the way, in New York Supreme County as well as Nassau Supreme, when you take out an hour for prep time. At the end of 3 hours, defense counsel did not make a counteroffer to plaintiff's mid-six-figure, and then these are large corporations, by the way, that we're dealing with a case in matter of controversy over $50,000. Right? And again, everybody was lawyered up. Defense counsel agreed to schedule the second session pending client approval. The day before the scheduled second session, defense counsel telephoned to cancel. Her client did not want to pay me my lowly hourly rate of $300 to be split by the parties, or approximately $450 for 3 more hours, which would equal $150 an hour per party for 3 more hours, or if completely amortized, $75 for an entire 6 hours. All right, so she did some pretty nice math there. And then Ms. Paula concludes, so there I was giving my time away for the public good in a room where all of the other professionals were being paid hundreds of dollars per hour. I do not know which was worse, that defense counsel abused both the court and me by agreeing to attend the mediation. He knew would go nowhere simply because it was free, or that the court initiated the quote abuse, again, her word. But I do know that the meaning and spirit of pro bono has truly gotten lost somewhere in the history of this program. All right, then we have an article now moving into diversity considerations. And we have this from Jeff. So thank you again very much, Jeff. And he, in this article, again, I can't read through the entire thing, but he brings out the general point that for diverse mediators who are up and coming, it's very difficult for them to get experience. And in that regard, he was talking about how when diverse mediators are put into programs where there are more experienced mediators, well, it's very difficult for them to, I would say compete, but to stay in the same zone when those people are expecting, let's say, the more experienced levels. They're not necessarily there. It's also difficult for them to gain experience just in general, where people are not willing to pay their mediators past the time for what it is. And so in that regard, Jeff is saying that the time-based programs and free mediation programs, as they have it, actually hamper diversity because it's more difficult for diverse mediators to move up. Right? And in so making this argument, right, he ends up, and where was it? That's what I wanted. Quoting the Universal Declaration of Human Rights, right? The fundamental moral obligation runs the other way. The essential moral tenets of our society require all of us. He's answering the question here is, should mediators basically have free work? Should mediators be expected to do straight pro bono work? Should the expectation be for no compensation? The answer is that as the fundamental moral obligation to compensate runs the other way. The essential moral tenets of our society require all of us to compensate other people fairly for valuable services provided if we can afford it. Is this kind of language overly highly minded? No, just take a look at Article 23, Section 3 of the Universal Declaration of Human Rights adopted on December 10th, 1948 by no less an authority than the United Nations. Quote, everyone who works has the right to just and favorable remuneration, ensuring for himself and his family an existence worthy of human dignity. There's no carve out for mediators. And at the end of the article, he has a very interesting point. And Gary, we're going to do, I saw your point about in the chat and what else. Well, I see your hand raised. We're going to do a chat-based order when we're done, just with this quick presentation. I'll be done relatively shortly. He said already 20 minutes, I'm almost there. But he has a pledge, which he wants lawyers to take, is that it's essentially in any case where I, as an attorney, am being compensated in market rates for my services, I will compensate the mediator at market rates as well, thereby achieving a parity so that everybody ultimately gets compensated. Finally, last but not least, since John is on the call, I want to turn to the current state of presumptive ADR, where John does state right out something which I think some people certainly on this call are interested in, is that mediators getting paid. He writes, with all of this voluntary generosity, eventually skilled and experienced mediators are going to want and will deserve to get paid. And already skilled and experienced mediators may become unwilling to join and remain pure volunteers, speaking about the New York system. To get high-quality mediators, the number is sufficient to permit effective presumptive early mediation of a truly significant percentage of disputes. It will be necessary to provide compensation. Now comes the question that some people have expressed. How do we do that, though, without violating the precept that private citizens should not have to pay extra costs for private mediators as part of the price of litigating in New York's public court system? I'm just reading what he says, but a quick commentary on that. John, I'll just tell you that people are already paying extra costs for private mediators when they're paying their attorneys as part of the very process as well. It might be indirect. That's my quick response to that. Then John gets us into where we're going right now in terms of comparative analysis and states. This was a very useful article. Just a quick shout out to Jeff Kachavin again for bringing this to my attention. This, by the way, just in terms of the chronology, is current. This is May 2021. This is where we are today. This article was published on CPR Alternatives. For those people who are members of the International Institute of Conflict Prevention and Resolution, that's CPR, was published on April 26, 2021. So we're only talking about a week ago. This is straight out current. And again, you can get this all from my main page. He talks about Florida and New Jersey. Now, that's where I want to begin. Just a quick point on the comparative analysis, but to bring out the point that Evan talked about initially. Let's just take a look at very quickly at New York. All right, and again, at this table, you can see what we have. You have the link to my petition over here. I'm not going to open it up, but that tells you the general status of the free time programs that you have in New York with respect to 90 minutes to 3 hours. I've summarized that in the compensation amount of details. Now, if you take a look, though, at the federal courts, and again, the Western District of New York and the Northern District of New York are similar to the Eastern District of New York, which I have here in the chart. I do not have the WDNY and the NDNY yet. They will be coming, by the way, for those who want to know, it's $150 an hour for, I believe, the first 2 hours, and then $325 there afterwards for additional hours. In the Eastern District of New York, the compensation is set at $250 an hour for $250 for their services in each case for arbitrators. And for mediator compensation, it's a rate of $600 the first 4 hours. That's $150 per hour. So that's commensurate with or parallel with the Northern District and the Western District, and $250 per hour for each hour thereafterwards by the parties, but without any preparation time being compensable. Again, if you follow the links that I have over there, which are all hot, you can see they've just started up a trial-ready rapid mediation pilot program because of COVID, right, as opposed to some other aspects before. Now, the other aspects, meaning the disaster or some other type of that, is there. If you take a look very quickly at an article that was put out on the John Jay College of Criminal Justice website, this New York City market standard. I should not say this is from the state. From TIFs becoming a mediator in New York City, it says that average fees in New York City are $300 per hour for private mediations, whether in family, workplace, or commercial cases. By the way, quick shout out to John Newman from the City Bar for putting this out. Attorney mediators and mediators who are in greater demand may charge more. And then again, it talks about federal compensation. So we see that federal courts in New York, with the exception of the Southern District, that's the only one which is purely pro bono, and no compensation. For the federal courts in New York, go to 28 U.S.C. 658. That's the Alternative Dispute Resolution Act of 1998. All right, and you'll see already that for 20 years, the courts have been empowered. If you go to that statute, it basically says each district shall have the right to set whatever rates it wants for the compensation, to make compensation principles for their arbitrators. Very quickly, just to go to New Jersey, since it's right above, all right, as a comparative rule. New Jersey, it's very interesting because New Jersey does have, as John described in his article, a compensation scheme which is somewhat similar to New York. 2 hours is the rule there. But what's also interesting is a very comprehensive guidelines for the compensation of mediators that provides for something which is the equivalent of Rule 7C in the Part 146 rules of New York County Supreme Court, that basically says that we have a default, but if the parties want to alter what's going on in terms of the compensation by agreement, prior agreement, they can, and they have the opportunity to do that. Right? Other programs such as Nassau County do not have that 7C option for going with other agreements. But in terms of the guidelines, and I obviously can't reproduce all of them over here, it's interesting because some of them are more pro compensation in terms of what we have in terms of market. Some of them are more not so pro compensation. Again, just, if you don't mind, I'm almost going to be done. I need about 2 more minutes. Just please, everybody, just keep on muted, and we'll open the floor for general discussion. Just very quickly, what's interesting to note about the New Jersey guidelines, which again, they are pretty robust. Right? It's probably the most robust guidelines in terms of compensation, just on that topic that I've seen so far. That might be something else out there. I mean, Colorado has some interesting material, but they do say in guideline 15, in a complex case, if the parties agree that it's reasonable that preparation, initial administration, and the organizational telephone conference should exceed 1 hour, there you could split that 1 hour, the 2 hours into 1 and 1. They may agree to compensate the mediator for such time in excess of 1 hour before an in-person mediation session is held. So insofar as New Jersey does provide for those 2 or 3 hours, it also provides for compensation for prep time, theory, prior to the actual mediation session being held. On the other hand, travel time and other expenses can't be included. And as I write over here, guideline 11 goes even further to require mediators to actually take losses on expenses that are typically paid to attorneys in litigation. And again, unless the parties agree otherwise in writing in advance, following full disclosure, mediators may not charge for travel costs or time use for rental of facilities, paralegal expenses, food, photocopying, postage, conference calls, or other expenses, except for what they have in guideline 6, which for some crazy reason goes to back to conference calls. Conference calls apparently are accepted from that, but everything else is there. In the age of COVID-19, I could say everybody has many more technological expenses than we ever have before. All right, so when we're looking at rules like this, even if we're not meeting in person, these rules, these guidelines effectively require mediators to take losses. Insofar as these expenses won't be compensable unless, of course, it's agreed otherwise. Right? And again, there are some programs in New Jersey where the compensation rates have been set. And this goes back to what OCA's general position is that we need a statute. We need something on the books which actually will enable us to do that. I encourage everybody, I want to finish my presentation because I said I would be relatively brief with it. I see I've already gone over a little bit. But I do want to encourage everybody to view the rest of the chart. There's some very interesting statements here, including a statement from the Georgia Supreme Court regarding the requirement that, or I should say the advisability and the need. It really is a requirement. They have it. I'll just go to it very quickly for mediators and as well as neutrals and beyond that to be compensated. And you can see that right over here. Although the contribution of volunteers to APR programs throughout the country is inestimable, the Georgia Supreme Court believes that the comprehensive system of statewide APR services envisioned by these rules cannot be handled entirely by unpaid volunteers. This court is convinced that in order to build and maintain a statewide system of APR services of the extent and quality desired, there must be mechanisms for compensating neutrals at appropriate levels. And again, everything on this chart is hyperlinkable, so you can go and click on anything that will come up. I'm just going to do a very quick example. As you see in Kentucky, I just brought it up on the screen. Mediator compensation. Kentucky is a reasonable compensation state. Sometimes you have states which have statutes basically say we give reasonable compensation, and that's it. They don't define it further. Other times you have states which are like Jersey, for that matter, which are extraordinarily intricate and complicated. The last thing, though, that I just wanted to point out, though, in this particular chart, before opening everything to the floor, is Vermont. And I just had it up there. Here we are. Vermont is interesting insofar as the Constitution itself gives you your enabling power. And then from there, the courts have various rules. All right. So in terms of the way the structure is set up, the rules for compensation, as you'll see from the rest of the jurisdictions, that's not what's interesting. But the Constitution itself gives you the ability in Vermont to actually create the rules. And then from there, various programs, and this is what Evan was alluding to before, there are various programs at various levels throughout all of the states, and also including your family mediation is different than civil mediation, that arbitration. And believe it or not, as I found out today, in Alabama, they're actually, I'm sorry, not in Alabama, in Alaska, as Federica pointed out to me, in the attorney-client fee dispute program in Alaska, there's actually a mechanism for those arbitrators to be compensated, whereas in all of New York, this is one thing which is uniform, there is no compensation for fee dispute resolution program mediators or arbitrators of Part 137, because that's just the way we have it. And again, there's something to be said for pro bono programs. I don't want anybody to come across from this thinking that I or any of my colleagues at NICLA are against pro bono programs. They're great. I mean, I happen to be a Part 137 arbitrator and mediator with NICLA. I do not expect any compensation for that. Insofar as that's the rules, that's what we're getting into. The trick is when we have to strike a balance, and that's what we're going to talk about right here. But as you can see, the one thing that the Vermont rules have, and one or two other jurisdictions have this as well, is they have fee shifting. They basically state that if parties go through a process and they go through mediation, and then a party, they go to litigation, and parties, a non-prevailing party ends up, having to pay, the mediation costs can be shifted to the parties at the time. So that's something we just to consider. With that, that's the status of everything. Again, I encourage everybody to go to the chart that's in the petition itself, or again, you could just email me for that. And I'm going to stop the share right now and open it up to the floor. So let me take a look at the chat. I saw Gary had his hand raised before. So we're going to put him in line first. I don't see anybody else in the chat, but just very quickly, the rules here going forward are that I'm going to let everybody talk, and I'll stay on for as long as I can. We called this for 5. If I can, I'm sorry, we can go for more than the hour than we have right now. But we'll start with Gary. Anybody who wants to speak next, though, so this way we don't have one person talking over the other, please put your request in the chat. Don't raise your hand. The reason why not raise your hand is because I and my co-hosts, which would be Chris and Nelson, cannot see that in terms of an order. We can see that much better in the chat. So without further ado, Laura, I saw you wanted to go second. If that's the case, there you go. Thank you very much for putting in the chat. So our order is going to be Gary first, Laura second, and then anybody who wants to speak afterwards, go ahead. Gary, the floor is yours. Gary, you have to unmute. There we go. And if you can't turn on your video, please also.
Yeah, I lost my internet connection for a second.
No problem. We can hear you, so if you want to go ahead, go right ahead.
So I may have missed the last few minutes. My comment to you was, I think most of us are on the same page here in terms of believing that mediators should be paid for their work, and that includes prep time. Now, we probably also acknowledge that there are various limits, such as small claims court, things like that. I don't know, again, how far this discussion has gone. In terms of enabling legislation, one of the concerns that I have and some other people have is be careful what you wish for. I did notice the some part of the New Jersey statute had a maximum of, I think it was $70 an hour, not more than X per day. I see you're shaking your head, Laura. I was just reading what was on the what was on the screen before. But one of the concerns in general I have is maximums being set of amounts that none of us would really be very pleased with. I think in terms of free prep time, that's not ideal. The 90 minutes, personally, I don't find a particular problem. And that I think that may be more of a practice issue than anything else. But I do think we're in this transition period right now, and that some of the rules coming down, while not ideal, especially in terms of free prep time, or even the 90 minutes, in fact, do not place maximums or unreasonable maximums on the amount that can be charged per hour. And I would hate to undermine the good aspects of that while we seek to get something that could be very difficult to get, and something that could be worse than what appears to be developing at the moment.
Okay. In terms of a response to that, what else? There's always the possibility of what ifs. And that's why I specifically left the petition, quote unquote, remedy very broad and very open. I think that what the federal courts did with the Alternative Dispute Resolution Act of 1998 is they set us a trend. They showed us that we have one law, is a concept in federal law, the uniformity and centrality of federal legislation. So that essentially the federal courts, to a certain extent, are all playing more or less with the same set of rules and guidelines and principles. I think they did that by, in terms of the legislation from 28 U.S.C. 658, by leaving it, broadly open. And then to the extent that there are different needs for different jurisdictions within the state, and what else? Once we have that enabling legislation there, then great. But the enabling legislation, if you saw what we added, I don't know if this is when your connection was knocked off, Gary, is like very much what you have with Vermont. If Vermont has a rule which basically says the courts have the right to make their own rules regarding procedure, and since mediation for them, as far as they're concerned, is a court-annexed procedure, it's part of the actual procedure of the litigation, the courts now have the right to make their compensation rules. I don't see that necessarily the parade of horribles that you're describing, Gary, would come just from having that. It might come from other legislation, and again, what legislatures might do with this particular petition and where it might go from there. It might go south, it might go north, it might go any other direction. We don't know, you're right, but we can't live our lives based upon what ifs. Otherwise, what you're going to have is, and I've seen it in my bar association meetings over and over and over again, people have constantly brought up the issues of compensation. It's not only with nightclub meetings. I've seen it in mediators meeting online where we have mediators from all around the world, literally. I've seen it in groups with the National Association of Distinguished Neutrals, where Krista's been involved, where Janice Sparrow is also as part of that group, where that has come up before, where we've spoken about this, and it just is an issue which is not going to go away until at least we have something or the ability to remedy it, and that's my view of it. But okay, Laura was next in line to speak, so please, Laura, go ahead.
So I understand what you're saying, but I think we're talking to ourselves. We all want to be fairly compensated. There's no question. We all, and it is a profession and it needs to be recognized as a profession. That being said, and I have been in New Jersey this whole time, so I've watched the cultural change that presumptive mediation has caused there. It is now assumed by all litigators that they will engage in mediation, and many of them hire mediators themselves. Right off the bat, they agree or they propose. And there's market rates. But once you engage in this without even testing the waters, even testing what this is going to do and generate among litigators, and the courts are not very happy with this proposal now in the middle of their initial efforts to start this process. I think this is a bad mistake without further investigation. And I'd like John Kiernan to talk about the sort of broader thing that's going on in investigating what we need. We do need more mediators. We are going to need to compensate them, but we can't just take our point of view and assume you're going to get enabling legislation. I think that that's just a faulty way of looking at what's going to happen when you generate a discussion. John, I'd really appreciate your input here.
Since, by the way, just to the way we're going over here, there's no one else in the chat right now. So, John, I guess if you want to take the invitation, the floor is yours.
Thanks. I'm happy to. I think everybody recognizes, if you're looking at, hi, Jeff Kitchaven, nice to see you. Everyone recognizes that if you're going to have broad-scaled, truly effective, move the needle, presumptive mediation as a part of the dispute resolution process associated with having a litigation in New York courts, you are going to need a large number of, to get to that goal, ultimately, you're going to need a large number of mediators. They're going to have to be good and they're going to have to be paid. But you used the word transitional. And I think that's a really important word in this context. I think the sensibility as of now is that we're at the early introductory stages in New York of trying to build the concept of broad scale presumptive mediation. And when we're in those early introductory stages, we have a bunch of things that need to change. We have judges who don't have experience with mediation and who are extremely wary of requiring the parties to do something that involves their paying money other than the filing fee that they paid to get into the dispute, and think that they can't act in a way that imposes costs on parties without legislation particularly authorizing them to do so. You have lots of litigating parties who don't appreciate what the statistics are showing about the enormous value of mediation. I think everybody on this call knows that the pilot programs are consistently showing 50% plus settlement rates, which is just the notion that you can, at the beginning of a dispute, resolve something like half of them by having an upfront mediation among people who recognize that when push comes to shove, they don't actually have the resources available to spend litigating the dispute to a resolution because it'll cost too high a percentage of the amount of controversy. that's a powerful and transformative notion that is just now taking hold in New York. New Jersey obviously is way ahead, and we've been going to school on New Jersey on this. For the purposes of getting this going, you talked about a bunch of the economic laws. There's also the economic laws of supply and demand. There are people who are willing to volunteer to be mediators under arrangements where the introductory part of the first couple of hours are free, and then you charge after that. And so long as there are people who are willing to proceed on that basis, to build as a matter of public service, as a matter of big picture belief that this is the way to increase the demand for high skilled mediators like the people on this phone call, as a way of building credentials for themselves, whatever the reasons are, so long as there are that category of people who are going to do it. And critically, so long as they're good so that you keep getting these high numbers, you're going to be able to do some of these introductory pilot programs that are attempts to sort of develop the thing at scale. And one of the things that amazed us when we started talking to the New Jersey folks who are now, as people have said, more than a decade ahead of us, is that the percent, we asked that what we considered sort of the $64,000 question, but what percentage of people after they've had the 2 hours of free mediation say, okay, well, now the free part's over, I'm getting out. And the answer is an enormously high percentage of them stay in and start paying. And many of them even agree to pay for the first couple of hours. But I think those first couple of hours are going to be necessary to build the demand. They're also going to be necessary because courts are going to feel that they can't run a system on a broad scale unless it's available for people who can't afford to spend the extra money for mediators. So, but all the things I'm describing are things that are in my mind, and I think in the minds of the people who are advocates for presumptive mediation, categorically transitional. If you start talking about how are you going to have mediation for the hundreds of thousands of lawsuits that are brought in New York every year, you're just not going to get volunteer mediators at scale sufficient to do that. But if we can build through this process the kind of expectation that Laura just mentioned, that if you get into a dispute in New York, you're going to mediate. And some people, the people in the larger disputes, the ones who can afford it, going to private mediation, the other ones going to recognized programs, and the numbers build and people develop the experience of seeing what high settlement rates go to it. That's our belief, is that transitional period will be finite, and that in due course, what you'll see is something where because mediators are conveying something of value, the fundamental concept, they're conveying something of value that should be recognized by pay.
Okay. So I do have some comments on that, but I'm not going to say them right now because I do see we have other people here, and I did make a promise. I want to keep my promises. So Evan, you're next on the.
Yeah, I second most of what John just said. A couple of additional points. I don't think pay or non-pay affects a good mediator. A good mediator will give her best. Excuse me? Yeah, a good mediator. I think a good mediator will give her best whether or not she's paid. And I think no one, as far as I can see, is clock watching to see whether we're at the 90 minutes or the first 3 hours or whatever. I have yet in any of my mediations to find anybody point to the clock and say time's up. And in fact, I've actually gone over 3 hours or 4 hours, whatever the freebie time was, to 5 hours, and never billed parties for the extra hour or extra hour and a half. I don't think it's necessary to. And finally, free mediation is a good way, perhaps the only way, for new mediators to break into the field.
It's certainly an interesting perspective, and thanks for the contribution. Jess Bunshaft, you're next.
Thanks, Elon. Just want to comment just my own feelings and some colleagues who've commented to me, so you've certainly stirred some discussion, Elon, and that's always worthwhile. That it seems that under our current circumstances, as we try to build the utilization of mediation, that some portion of free time in the Court-Annexed programs is vital, not just because there isn't authorization legislatively for pushing people to paid mediation from minute one and for all the prep time. But I think a lot of us have seen, certainly I've seen, where you get people who don't even really know what they're dealing with. And in the 90 minutes, or in some cases the 3 hours, they recognize the value of it. And as Evan and others have said, you know, it's the selling period, for lack of a better way to put it. And then they keep going. I've had lots of them now just keep going. And yeah, you know what, we're having a good discussion. Sure, let's keep going without even hesitation. So I think there's great value there we shouldn't overlook. And also, as Laura said, and possibly others, I'm losing track of who said what, but we have to be careful pushing something like this forward. Once the legislature, if we were to get it that far, gets their claws into this, God only knows what they'll do with it. We could have, as someone said, an 18B like result in the end. We could have, you know, they could set some sort of okay pay rate we can charge and then not revisit it for 20 years. And then we curse the practice for 20 years. This is something that requires a lot of careful thought. And if anything, I think now OCA has been working very hard. Marilyn and I, from our role with the Nassau Bar, have been working with court reps locally and at OCA level to try to find ways to better the programs. Part of that may be standardizing that free period. There are a lot of things we can discuss. I just think we have to be careful about going too far too fast. I'll stop there.
Thank you very much, Jess. Dan Coyne ended up, that VM, by the way, is direct message. Those want to know the abbreviation stands for. Direct message me that he would like to speak next. So Dan, please.
Thank
go
you.
ahead.
Thank you. Appreciate it. Thanks for inviting me. I'm new to this party, but I'm nice to see Krista here, my colleague here in Western New York. Listen, I'm involved in some of these panels that the state has established in various judicial districts. They each have different rules, as we know. They all have some part of free, some free programming, free mediation, no prep time, couple of hours, whatever. In the Bronx, and some other judicial districts, the state is trying very hard to get this program underway. I agree with, I think it was with Evan who commented that this is a good opportunity for people to get into the process, and I think it also will lead to private mediations for those who have been effective in mediating in this system. So we have to be careful. The state is trying. I think this will expand. Eventually, there'll be compensation available, probably for a greater amount of time. But you know, so far, I've had 4 or 5 of these mediations. 2 have resulted in actual cash payments because we went beyond the time periods. Other ones were free. 2 were resolved, 1 wasn't. So far, it's not a big deal.
Okay. Oh, we don't have anybody else in the chat yet. So would anybody else like to just jump in at this point? No? Okay, so then I want to take a couple of minutes just to give my perspective. Oh, there, Marilyn, go ahead.
I'm so sorry. I don't really want to say a lot because I think we've been on for a long time. I just want to say that I mentioned this to you earlier. I don't believe that there's anybody on here or any of our colleagues who don't believe that at the end of the day, mediators should be compensated. However, after listening to people that I think are extremely bright and have been involved in this and have history, I believe that it's something we need to do with caution, because at the end of the day, building up the credibility and having people understand what mediation is. I mean, we still have some judges who still confuse mediation and arbitration and settlement conferences. So after we've educated people, and we're really on a good road to do that, and have people understand how beneficial it is. I also have had the experience that I haven't had anybody shut down, not once, and I've been doing them, getting assigned a lot of cases. I've not had anybody shut down after the allotted time. We continue, and the retainers say that after that time there'll be payment, and they pay. But as a result, I've had attorneys reach out and say, that was really good. And we'd like to give it a shot for this before we get really into heavy litigation. So it's not even waiting to be assigned. But I think we're building something. And I do fear that we may create problems unless we do this with great thought, and reaching out to people who have good experience with this. That's all I want to say.
Thank you so much, Marilyn. Krista, you're next. Please unmute.
Thanks, guys. Well, I fully agree with the gesture and the sentiment that we need to be careful. We need to proceed slowly. We need to make sure that we don't overload. We have to make sure there's paradigm shifts. With all due frankness, with this group only, I've been doing that for 27 years. It takes a lot of paradigm shifting, and we're having this conversation because the courts have finally caught on to the fact that mediation, which was not originated with the courts, is something that works and something that can be made to work with the court system. And we made that happen. We mediators with some of the leadership, some of which are present here. I think that is important, and we need to listen to the voice of what is necessary to achieve it. However, I think it's also necessary to build in the next step. If you transition, you have to say what the next step is. So if you're going to have rules about freebies or controlled rates or lower rates, then it has to be built into the program that at what point does that go away? At what point does market control? We don't control attorney rates. Why are we controlling mediator rates? And those are the kind of things I think that need to be built in. I fully agree we have to be very protective and very collaborative and very cooperative, while at the same time we have to assure that the system is going to have really good folks that are paid in the future, and that we get through the transitional period so that we don't have the, well, I've been getting it for free, how come I have to pay for it now? It's been a long time.
Okay, so another perspective. While we're waiting, I'll have a little bit of a chat break over here. Anybody wants to come in and say something, please put your preference in the chat. We don't have anybody else next in line. But I want to just quickly relate a email that I received this past Friday regarding the petition from one of my fellow special masters in the appellate division. And in that regard, I just want to point out the appellate division second department mandatory mediation program is a bit different. And I'm deliberately understating that. It's a bit different than all of the other programs that you have in the New York presumptive ADR universe, insofar as it is a post-perfection program. It's not a pre-perfection program, meaning that when you have attorneys who are in this program participating, they already have fully fledged briefs, records which can very well exceed, as in the case that I referenced in the petition obliquely, 12,000 pages. And that can be presented to a special master, and you're usually given the same 30 days to chunk all of that as if you were to have a simple X versus Y corporate minor contract dispute in Part 146. The time frame is more or less the exact same time frame. It's just the level of complexity is much higher, and you're given 90 minutes on it. And I can say that in every single one of the cases that I've had, including that mammoth 12-party case, I've had issues. It's not to say I haven't broken it. I have broken the barrier, and there are ways to do it. You can, as Jess was saying before, sell people on it. But in every single one of the cases that I've handled, that particular time barrier has come up on two accounts. The first is that the parties, really more their attorneys, the parties don't opine so much on this, but the attorneys are pretty much against the whole concept of having to charge their clients for going to a mandatory mediation program, when mandatory mediation, as far as they're concerned, when they read about mediation, is a bit of an oxymoron. The whole concept of presumptive mediation, as far as they're concerned, that they're ordering their clients, especially after they sunk all the work and time into doing their appeals, to them is not worth it. They're convinced that they're going to win. And I've seen this in pre-mediation statements over and over again. I asked them, please describe what are the weaknesses in your case, or alternatively describe how you think playing on farther down the line, an appeal could go against you. And inevitably, I got the same response. We will not lose. Right? Well, statistics, 2/3 out of the time, attorneys are correct. 1/3 of the time, they're not. That's what it comes down to. And when you're dealing with big cases, one of the cases where they were wrong about, the amount of controversy was over $1 million, the stakes are very high. But the second point that they bring out always is that if we're going to be talking about what we're getting, I want my clients to get the best value they have. I don't want them to pay anything more. They've already paid me, or they still have yet to pay me, which is even a worst case scenario, thousands of dollars, if not hundreds of thousands of dollars, to get these appeals ready to go. And in this case, congratulations, Mr. Mediator. You might be doing a great job, and we applaud your initiative, and we see this could work. But guess what? Our clients are just not satisfied with this. They don't want to be here. The court is forcing them to be there, and that's why we're going to cut you off at 90 minutes. And that's been just generally my experience. On the trial level side, it's interesting. Sometimes, as Jess was describing, I've had one or two cases where the parties were very much ready to go, and they bought it ready. So far, the best case that I had was thank God, was able to successfully mediate a case where the parties had been in litigation for 8.5 years in 2 separate courts. And in the course of about 5 hours, I was able to, thank God, get them to reach a settlement. Not a super complicated dispute, but it was complicated in terms of the facts. It was piercing the corporate veil and a bunch of other business torts that they went into. In describing what went on. But the point is that in that case, the attorneys both were very receptive to the whole concept of mediation. They saw the economics. They already had been in trench warfare for all this time. And this was a case where, if you take a look at Jeff's article, they really were asking me to tell their clients that it was time to put down the swords and to end this thing. For me, it was time for me to give them the bad news, going back to his 2004 article. And in that case, the paradigm worked very well. They did make a whole point about saying, when I did reach the 3 hours at the time, I did mention it as a point. And they said, look, at this point, we want to go for a little bit more, but then afterwards, we want to stop. At that time, I thought that they just were using the 3 hours for what it was. It turns out that they then ended up having some discussions afterwards, and they called me back in, and thank God we were able to get the case settled. But that's the exception, not the rule. More often than not, I've been in cases where every time that it's come up, the 3 hours or the 90 minutes or whatever the time barrier is, the time restriction has been weaponized. And it's not just the fact that we necessarily mediators getting paid. There's also a threat to the process itself and the integrity of the process when you interject a time restriction. And it might be a separate issue, separate and apart from compensation and what it comes down to. But mute out that sound. The issue when we have a time barrier or time restriction, especially in this, I want to just quickly point out something what Gary said before about training. It very well would be something you might be able to be trained in. You might be able to be trained to be a salesman, right? But the way that mediators right now are trained, and I've gone to a number of trainings, and I've given a number of trainings. Right? In pro bono programs, obviously, this doesn't factor, because when you're doing a pro bono program, there's no time barrier. But when you're dealing with a time barrier, and when you have something on that line, it's something which, number one, people pay attention to. Number two, it's weaponized. And when it's weaponized, it affects the integrity of what you're doing. I had one person in a mediation tell me straight out, you better finish this up quickly because you have 32 minutes left. And after that, I am going. And there's nothing you can do about it. And you can't say that it's, as opposed to some states, by the way, that have a quote unwillingness to participate is evidence of bad faith. Shit like that. We don't have that. And they're right. They're within the rights to do that. And when you have to report on the mediation, they have to say statement, did the parties meaningfully participate in the mediation? Well, as far as mediation is concerned, based upon confidentiality, if they open up their mouths and they say, hi, my name is so-and-so, this is my position, I'm not deviating from it, have a nice day, they've meaningfully participated under the language of the statute. So you don't have any remedy for sanctions. And the reason why they're doing that is because of the time, and they weaponize it. So it's not so much the fact that we need this way I view it, legislation just to make sure that mediators are fairly compensated. We definitely need that, and for all the reasons that I stated that before. But in addition, I think we need to just turn the paradigm around in terms of the time barrier, just get rid of it. Either make it one way or another, either make it completely pro bono or make it low bono or do something. But to keep a time barrier in, and yes, John Berry had some wonderful statistics in his article, and it's great that we're in this transition period and that presumptive mediation is building and what else. But think about all the cases that in which a time barrier came into play, that someone weaponized it, that aren't being resolved. And statistics aren't being kept on those. And what's happening ultimately is that the program, while it's working well, and it certainly has a baseline right now, it's not working as optimally and as efficiently as it could possibly be. And that's my particular view on this, is, in terms of just beyond the compensation. It's an aspect of the process. When we go back to training, from what Gary was talking about before, I was told in my initial training for advanced commercial by Simeon Bound, tell the parties they'll be given all the time to speak. They will be given their opportunity. Make them feel at ease. Cheerlead the process. That's almost the exact words that Simeon used in his training for what else. It's very difficult to cheerlead a process when the other party has weaponized an aspect of the process against it, to torpedo everything that you've done in terms of your preparation. And so that is really a secondary aspect of the petition and the drive that I have for this. I happen to agree with what a lot of everything that everybody said over here. Very often these issues are never black and white, and what it is. And I think, what Laura just put into the chat is correct. More research is necessary, and more, investigation certainly is going to have to be done. And that's also why I was telling some people before informally about this topic. I put 15,000 signatures as the magic number because it's going to take time. I'm not going to get 15,000 signatures on this petition overnight, even if it went super viral. It's not one of these types of petitions that's going to go there. It is somewhat tactical. And people who understand what's going on are onto it. Some people who are, as we have over here, are not necessarily ready to sign on yet. I hope everybody just got that quick reframe there. But people are not necessarily willing to sign on yet to it because of the dangers that are involved. And I hear that. I hear what's going on. But the flip side is, if we keep this paradigm in place, we're going to have issues. So I want to just quickly relate this email that I started with that came to me from a fellow special master. I don't know if he wanted his name revealed, so I'm just going to not even give his initials. Right? It was a person who has been very experienced. And he wrote me stating that he was in support of the petition because of his compensation statistics on the special masters program only. Before it became the mandatory mediation program, it was the mandatory civil appeals mediation program. But when he was with it since the beginning, he actually did, and I don't know how he pulled this off since the time this was going, but I guess he was one of the first. He did 50, not 15, 50 cases. And he received a total of $200. All right, with that, now it could very well be that he's doing litigation, on the side. It could be that he has the pro bono mentality, that Evan was speaking about before, and that could be great, what he's doing. But it's obvious based upon the fact that he signed the petition that at some point, maybe perhaps effort justification caught up with him. But if you take that math into consideration, it is egregious that a person should be working at a high level in terms of the mediation world and the appellate division special masters program to work on 50 cases to get a total of $200, and of that $200, he got stiffed on 100. So that's the way I see things like that. The outcome like that is inequitable, and that's where we're coming to. So yes, do I see that we need to be extremely cautious? Do we need to tread carefully and proceed with caution, as the expression goes in the courts? Absolutely. But at the same time, how long are we going to be in transition, as what Krista was saying? How long is it going to be 27 years? Is it going to be 3 years? Is it going to be, what else? Okay, Chris, you did put it in the chat, but Evan started to say something, so I'm going to let him go first. Evan, go ahead.
Thank you. Just a couple of side points. What do you think about, first, all of the state courts statewide having a consistent policy, whatever that policy is? And the same thing on the federal court side, the federal courts having a consistent policy. And secondly, what do you think about a mandatory requirement that all new arbitrators breaking into the field take on at least 4 free pro bono cases before they can take on any paid cases?
Okay, so Evan, those are 2 great questions. The first question, if it's something which people vote on and it's the will of the people, then certainly a uniform policy is great. On the other hand, there's certain dangers to it. For example, people were mentioning about what happened with 18B attorneys, and economics shift over time. I think what the federal courts have right now is good because they have a uniform policy that's dynamic. Their policy is basically that every district shall uniformly be enabled to do what they need for their people within their district. And I think just overall, and certainly I'm not an expert on this, and I'm not a legislator, and I'm not a policy guru or anybody who studied these types of macroeconomic trends or macro political trends for an entire nation or even a state and what else. But my view on that is that that's the best compromise solution, is that you have that enabling legislation, but when you still have the room for maneuverability, because a static system is dangerous. As to your second question, guess what? I'm seeing it as I'm doing this research that there's a requirement usually to do 2 pro bono cases, whether it be arbitration or mediation or what else. Okay, Jeff, I see you're about to come on as well, so Chris will be next once I just finish this. But usually is a requirement to accommodate pro bono cases for people to do 2, whether it be 4, whether it be 3, whatever it would be. Usually it's 2 as the number. But I think, yeah, it's a good idea. Certainly pro bono is great, and certainly it's an experience builder, and it should be part of everything. But it shouldn't come at the expense of people potentially losing their livelihoods. Very quick point, by the way, take a look at the chart in Illinois. You'll see in Illinois, there's actually a very interesting pro bono policy that in some of their counties, if you end up having a case which is pro bono by one side and one party pays and the other doesn't, they actually allow that for a split, then you can actually get pro bono credit for those types of half cases, thereby making it a low bono case. But those are my answers to your 2 questions. Chris Fladgate, you're next, followed by Jeff Kitchaven. Go ahead, Chris.
Hey, hi, everyone. I think just listening to this, I think on this process, we just need to keep our minds open to alternatives. And I do apologize. I had to take a call for a short while if this has been said on the call. But there's been an assumption that in the freebie time that the parties get with a mediator that we're talking about, that if we remove that freebie time, the cost would be borne by the parties. Now, there might be other sources that would be able to pay the mediator for that freebie time before the parties start bearing the cost of the mediator. One idea would be to raise costs within the court system so that more documents attract a filing fee, or the filing fee for documents that already have a filing fee is increased. From my very limited experience in New Jersey, I'm not admitted there, it seems you have to pay a fee for filing almost any document. But that's just a hypothetical example, and apologies if I'm incorrect. So, there could be, ways here of funding, even at a lower rate, a mediator, say, for the first 90 minutes. And if the parties go beyond that 90 minutes, then the parties pick up the mediator's fee at their rack rate or something like that. And I think that still encourages high quality applicants. It still encourages sort of that level of community-minded service. But it's just, but I go back to my original point, which is, we should sort of pick up the Rubik's Cube and look at it from every angle here, and not just sort of assume that there's only, one solution to any problem that is discussed. But I've really loved sort of a lot of the opinions that have been put forward here today, and thank you to everyone for jumping on the call.
I echo that. Thanks. Thank you so much, Chris, for your comments, and thanks for everybody again for their participation. I know it takes time from this, and as we're discussing here, time certainly is money, so thank you for your contributions. Jeff Kitchaven, you're up next.
Thanks, Elon. It's great to be here, see people, a lot of old friends, including my law school classmate, good friend, John Kiernan. I can assure you, you look the same, John. You haven't changed. A few points, having gone through all this in California over many years. One is just a note of caution on what we're requiring people to do. People, the litigants, have a constitutional right to a jury trial. And there are questions as to what we can do to burden that right, to put other obstacles between them and their right to a jury. So even if it's free to them, it's still time, even though if we mediators are free to them, their lawyers are not free. They have to pay their lawyers, or if they have contingent fee lawyers, it's an investment of time on the part of those lawyers. If people come to a mediation and simply say, I don't want to settle the case, period, well, they do have a constitutional right to a jury trial. We don't beat settlements out of them any more than it's appropriate to beat confessions out of criminal defendants. So just a note of caution on the coercive nature of what we're doing with people. In terms of mediation becoming presumptive, the question that I ask myself is, how does mediation become presumptive, and how ought it to become presumptive? Should it become widely used because it's good and people know about it and come to learn that it's a beneficial process for them? Or is coercion the way to do it, having people ordered into it against their will? My sense is that it's the responsibility of the mediation community to convince people, based on the merit of what we do, that we ought to be hired, and we ought to be used, and we ought to be compensated fairly. It's not the obligation of the court system to develop mediation in a community, or the idea that mediators should be paid. I do think that if you have a community where mediation is just not well known to people, yes, it can make sense to have some kind of a court-annexed program as a jump start so that people realize mediators don't bite. The problem is that once you get a government program established, it's harder than you think to put it out once it's outlived its usefulness. And I think that was certainly the experience that we had in California. Another point worth making, just in the way people use language, there's a distinction to be drawn between mediation that's pro bono and mediation that's simply free. What we found in California was that we were not providing pro bono mediation services solely for people who would generally be entitled to pro bono services. That is, people who can't afford a mediator. And of course, in matrimonial or family law, domestic relations courts, you find a lot of people who are not represented by lawyers because they can't afford them as they're getting divorced or have other matters before those courts. And I think certainly if people really can't afford the services, then yes, some kind of a pro bono program is appropriate. But what we found in California was that we were providing free services to Fortune 500 corporations, multinational insurance companies, AmLaw 200 law firms, who are really not entitled to pro bono services. So keep in mind, what is the difference between pro bono and services that are just free? My own experience with it, the day that I got off all of these free mediation panels was one of the best days of my career, because it ended, for example, such things as people calling me and saying, well, Jeff, we know you've only signed up for X number of cases on the panel per month, but won't you do ours for free anyway? And I would say, well, no. And they would say, well, we'll just move on to the next mediator. So I found that by placing myself on those panels, I was being put into a position where it was financially impacting my practice. I would approach these panels as a way not only to, in a more idealistic sense, do some public good, but also to develop my practice, giving free samples to people in a sense. What I found was that really didn't work either. What I found was that people to whom I'd been giving these free samples were continuing to come back, not with an agreement to pay me for a full day of work, but rather they continued to want the first half day for free. And when I realized that I was just putting myself in a position where it was hampering the development of my practice, hampering the attitude that I brought to these mediations when I felt that I was being taken advantage of, I dropped off these panels. It was a tough thing to do because it did cause a reduction in the traffic, the number of cases I was handling for a period of time, but that built back up. And I'm very happy that I don't serve on any of these court-annexed panels anymore. Elon, I don't want to rehash all the points in the various articles that I've written. The general belief that I have is that the world of alternative dispute resolution is ideally just that, a world of alternative dispute resolution. And we are healthier when we have a greater wall of separation between ourselves and the court system and not a greater integration. Thanks for inviting me to the meeting.
Very well spoken. Thank you very much. And thank you for your perspective. Gary, you're next.
Okay, thanks. Yeah, I think that in my mind, presumptive mediation really means presumptive mediation. It's what the Western District and Northern Districts of New York do. And I know Krista is very familiar with that program, those programs. And it means cases come in and they go out to mediation. That's what is meant by presumptive. And there are certain exceptions. People are allowed to opt out, but opt out is not easy. It's not that we don't think this case can settle. It's not that it's inconvenient. And I think hopefully that's where New York is moving. In terms of that being coercive or mandatory, A, it is. B, courts require lots of people to do lots of things and they cost money. There's mandatory discovery. Mandatory discovery costs money. Having your lawyers costs money. The cost of mediation in comparison to that, especially because it tends to be split among the parties, is far less. And as we know, those mandatory / automatic / presumptive programs are enormously successful. And 50% is the typical settlement rate. Sometimes it's above that, sometimes it's below that. To the extent there's data, it also shows that cases that go to mediation that don't settle at the mediation get resolved more quickly than cases that simply go down the litigation route. So there are all sorts of reasons why courts should presumptively send cases to mediation. There need to be all sorts of protections. If you're talking about divorce cases, you have to be concerned about domestic violence, and that certainly is built in to most programs. I think in terms of requirements to do pro bono work, that exists in most programs to the extent people are required to go to mediation, but they can't afford it. People on the panels have to agree to do some pro bono work to cover that. So that can be accommodated. I am still concerned about going down this slippery slope of the legislation. I'm not really sure what it gets us. And I think to the extent free time is now being mandatorily provided, my personal experience is like Marilyn's. People don't just get up and walk out of the Zoom meeting at the end of 90 minutes. They tend to stick around. They tend to pay their bills. Like I said earlier, I think maybe there's some practice pointers. If people aren't doing that, what do you do to try to limit that happening? And that would be an interesting discussion in general. I think, yeah, I would say one last thing in terms of the process being mandatory. Mandatory mediation does not mean mandatory settlement. People, not all cases get resolved. Although I think in general, most mediations serve a useful purpose because they compress the issues, they compress discovery, and even when the case hasn't settled, not only does it tend to speed up resolution, but it makes the further litigation of that case less expensive and less time consuming because of what took place during the mediation. Do we all want to be paid for what we contribute? Absolutely. Absolutely. Should we be? Yes. I think we can figure out ways to make that happen more fairly and more regularly. I am concerned that seeking legislation at this point could turn out to be a very mixed blessing at best. Maybe this should all be revisited now that presumptive mediation is unfolding more in the state courts. Maybe it's best to revisit this in 6 months, 9 months, 12 months, and see where we are and what we've learned and what might be most useful at that point going forward.
Thank you very much for those comments. Quick question for John Kiernan. Is there any way, you were talking about the scaling, is there any way that you see the scaling within 6 to 9 months, the time frame that Gary just mentioned, of coming to fruition?
Not for, I was just on a call earlier today who said, with a judge who said, so you tell me I should do presumptive mediation. There are 200,000 family law cases filed in New York every year. How am I going to do presumptive mediation of 200,000 cases? And the answer to that question is obviously you're not. For what it's worth, when I had a conversation with the chief judge on the scaling issue, I said to her, right now, if you add up all the programs, and we do have CDRCs, which are their own really important animal in New York that is different. But right now, with the CDRCs and with the small claims court mediations, which are also very big numbers. When I talked to her about this, which is a year ago, I said, you have about a total of 20,000 court-sponsored mediations a year. And that is almost all with either volunteer mediators or CDRC paid mediators or people who give their first hours free. If you talk to people, mediators on the panels that exist right now, most of them say that if they've got a complaint, it's that they don't get enough mediations from their panel membership. So my sense is that you could increase the burdens on existing panels by some degree without losing the people you have now. You also have a lot of people lining up to become members of panels, and you could increase the panels. And there are many places where panels don't exist. My very rough sort of back of the envelope, just for us to talk about it conceptually, is sense is that you could probably triple the amount of mediation you're doing in New York State, operating on the current system of uncompensated volunteer mediators and the CDRCs, which would get you up to about 60,000 mediations a year, which would be a remarkable, staggering thing. But since New York State generally has about 600,000 new filings a year, that's you shouldn't have any notion that actually moves the needle, but that it actually changes the nature of the dispute resolution process in New York. To do that, you actually need hundreds of thousands of mediations in a year. And that's the difference, of course, with the northern and western districts of New York that really do send every case, is that every case is a total of, I think it's 3,000 or 4,000 a year. It's fantastic, but and it's incredibly effective, and they have tremendous settlement rates. It's just not the same animal as the New York State court system, which is just operating at our gargantuan scale of complexity. Now, part of the difficulty is that in the New York court system, the percentage of cases that have enough money at stake that the parties would, in any circumstances, hire the people on this phone call who are highly regarded, high reputation, significant dispute mediators as the core of their, is not that high. One of the things we're trying to think about is how do you introduce this system, particularly to the tens or hundreds of thousands of cases where the lawyers know the day they get hired and the day they start the litigation process that they cannot afford to litigate this case to a conclusion because the cost of doing so is too high a percentage of the amount in controversy. That's a whole category of mediations that aren't really in our world, the world of the people on this phone call. They're small dispute matters where mediation can really accomplish a lot. And so there's a danger of sort of babies in bathwaters getting confused. Most of you deal with cases that are in the commercial divisions that have hundreds of thousands or millions or many millions of dollars at stake. In my experience, by the way, with those, when I've been directed to mediation to a court-sponsored mediator in a case involving a lot of the money, I have inevitably called up a lawyer on the other side and said, if we've got to mediate, shouldn't we just agree on getting a real pro? And we go out and hire somebody. And I think it's actually a mechanism by which people on this phone call get hired without being on the committees. I haven't had the experience of Jeff Kitchaven saying, let's look through the list of people on the panel and see who we can get for free, who's as good as what we could pay for. Because if you're seriously going to mediate, you want the best mediators you can if you can afford to do it. In the cases that involve very large amounts of money, you're going to go to private mediators. And the court-sponsored is really just going to become the assignment to mediation is going to become the lever that gets private mediators hired. And I think all of us are seeing that experience, especially as people are getting more experience with mediation. But that's a very windy answer to your question, Alon. But I think getting to scale in New York State is a daunting, enormous challenge that will take years. What I also think, though, is the transformation in sensibilities in the New York court system in the 4 years since the chief judge, 3.5 since the chief judge asked me to chair the ADR advisory committee, and since she got to the point of embracing ADR, has been staggering. And I think in ways that are great for the fair resolution of disputes, and also great for the mediator profession, because the number of participants in dispute resolution who've had the experience in mediation. I mean, I've always said, I've been saying for decades on mediation, there are two kinds of people. There are people who say mediation isn't an important component of dispute resolution, and then there's people who have experience with mediation. Because anybody who's had experience with mediation can't say it's not an important component of dispute resolution. So I do think there has been, I can tell you the reception from judges now to our pitches for building mediation into their programs compared to what it was when we started a few years ago, just transformatively different. And certainly the chief judge mentions it in her state of our judiciary speeches every year. It remains a very high priority for her. So I do expect a continued remarkable, staggering, almost breathtaking growth, but I don't expect we get to scale for years.
So it's something certainly to consider. Thank you very much for that very eloquent answer, John. I appreciate it. Maybe also in terms of viewing this issue, maybe sometimes we have to think inside the box so much as opposed to outside of it. Maybe we should think, aside from just training, as Gary seems to state it as a practice issue, maybe we should also think about having the courts do some more advanced screening. I mean, we saw in various materials $50,000 in California as being the cutoff there. Maybe we should have a policy, and again, for those people who are dealing with Judge DeFiore in upstate, this is for you guys. Cases which are $50,000 and above, they just don't get put into a presumptive mediation program that allows for free time. Instead, people have to pick from the courts, the state directory, which we now have relatively new, and from the state directory, people's compensation rates are listed there. That's the free market. It deals with the supply and demand. There's no free time when you're doing that. You go under the rules. It is still within the scope of the rules insofar as all counties provide that if you have a private mediator, you still have to function within the time frames and the deadlines that are established by the various rules. So that's just the parties picking a private mediator, which is allowed. But maybe that should be the determination. Now, is it $50,000? Is it $25,000? Is it somewhere in between? I don't know. But at least for right now, since essentially we're not going to get to scale, and since there seems to be certainly some reservations about going forward with the legislation until we get more information and more of a track record, let's say, ascertained, then perhaps that might be a solution. Again, I'm just throwing that out. But at some point, though, if we're not going to get to scale within 6 to 9 months and what else, then something's got to eventually be done, because at some point, there's just going to be too many cases with not enough mediators, and you're going to run into the reverse of the bottleneck. You can have the flood, and especially now with COVID-19. So, all right, that's where I see. Laura Castor wrote in the chat, can't we test the waters with other people, meaning non-mediators? Laura, could you expound on that a little bit? You're on mute still.
I'm just concerned that we're only talking to ourselves. Once you raise this in the legislature, or even with the bar associations, we have, NISBA has a lobbying arm. The other people get involved. The litigators get involved. The corporate people get involved. And it doesn't turn out the way you want to fashion it. So I just think that just talking among ourselves is not the way to go with something where you're actually thinking you're going to propose legislation. I think we need to find out what the reaction to this would be among the people who would engage.
Is that the lawyers you're talking about, Laura? Or
I'm
the
talking
courts?
about certainly lawyers and the bar associations, but even beyond that, is this going to be disruptive? Is this going to be ill received by the courts? Is this going to be ill received by the litigators who are so critical to changing the culture?
Well, but then the question, I think we could expand that. Are litigators really going to agree to any change in culture? I mean, there are some litigators who I've heard describe ADR as alarming drop in revenue, because as far as they're concerned, they see potential for an early settlement of the case. And as this is an old joke, you have a father and son law team. The father goes away on vacation in a case they've been working on for 20 years. And the son goes to the father, "While you were away, I had great news. I settled the case." And the father goes, "It's a disaster. You just bankrupted us." You know, so.
But I understand what you're saying, but that's my point. Okay, if we're talking to ourselves, we all agree we all should be compensated fairly. That's not necessarily what happens when you raise a legislative issue. Other people get engaged. And I think if without knowing what that might engender, it's a mistake.
Well, I just want to clarify one thing too. When I said 6 months, 9 months, a year, I wasn't referring to, I didn't throw those numbers out because I thought in that period of time, in fact, we'd have a presumptive program in New York where all cases went out to mediation, but just that in that period of time, the programs that are unfolding now will have unfolded a lot more and we'll know a lot more, which is perhaps related to what Laura was just saying as well.
Don't we now have presumptive mediation statewide? And aren't the only issues whether some of that mediation or all of it should be paid or not paid?
No, the programs are just starting. They really are not statewide. We have a system where we have independent judges, and they may decide on a judge-by-judge basis whether to do a program or not do a program. We have some programs, we have some buy-in, but we don't have a universal or uniform rule of any kind.
What is presumptive mediation then, if not a
That's Judge
statewide mandate?
DiFiore's hope, wish, and encouragement.
And so what's happening is that one of the vehicles for trying to expand mediation is taking cases of particular types in particular courts. The best example I can give is in New York County, for cases that would be referred to the commercial division in any other county in the state, but can't be because of the $500,000 threshold in New York County. There has been a pilot program run for the last 2 or 3 years for all cases that are commercial division eligible in everything except dollar amount. So they're under $500,000 commercial disputes. And that program is all cases of that type are referred to mediation. And that's got a 2.5-year settlement rate of about a little more than 60%. Fantastic. And there are some in Westchester. The Westchester Surrogates Court is trying to put all cases of certain kinds in the surrogate court to mediation. The reason for the presumptive is the idea is that the statistics, as Laura is suggesting, some of her texts, their chats, is statistics suggest that people settle disputes at very high levels, even when it's not their idea to go into mediation. There's lots of reasons for it, but I think one of the simplest reasons is a lot of people aren't willing to suggest mediation because they believe that suggesting mediation early on in a case is an admission of weakness. And so just telling me I got to do it. Okay. Well, I guess we got to talk about that. And that expression that others talked about taking off the warrior's hat and putting on the sensible problem solver's hat actually happens early on in cases. And sometimes early is a particularly constructive place to do it because it's before parties have spent money so that they can take money they'd otherwise be spending on the litigation and spend it on resolving the difference between them. But for the reasons I just mentioned in answer to Alon's questions. To get to presumptive across the board, you're talking about a scale that's so enormous that it can't be achieved. Now, you do have the recent programs there's a new recent a small claims procedure where they have hundreds of volunteers, many of them law students. The amounts of controversy are small, and they're available, and they're mediating disputes, and they're sending every case to mediation and getting humongous settlement rates. And by the way, the participants in the programs, the party satisfaction rates are through the roof for how they're getting their matters resolved through mediation. I think of that as the broad marketing of how mediation can transform dispute resolution. And you know, the paradox you mentioned, Alon, about settlement of cases reduces people's pay. You know, we litigators have dealt with that all our lives, and we've just turned it off. We've always thought that, you know, the main thing that every litigation is an audition for your next retainer by somebody else. And so you do the very best you can for the client at the cheapest way you can. The number of litigators I've seen who've actually padded their work to get more money for themselves has been small. And when you talk to the folks in New Jersey, they say that, a fascinating conversation. They said when they introduced these programs, the most intensely vociferous opponents were the matrimonial bar, who were like, you're going to completely ruin our profession. They said, if you eliminated the automatic presumptive mediation, early stage mediation from the matrimonial parts in New Jersey today, the matrimonial bar would be rioting in the streets because it's transformed the way they're able to get good results for their clients.
And Jess, I know you wanted to speak. Just an FYI.
Okay, here.
Divorce cases I got several divorce cases at this point from Kings County. Well, they've all been resolved. I've gotten some personal injury cases from the Bronx. They've been resolved. So these programs are on, and I've gotten paid, since I know that that's what stimulated this conversation. People are happy. They pay their bills. It's successful. And as that happens, this is a follow-up to what Laura was saying, the judges whose cases have been sent out become more and more receptive to sending out more of their cases.
It's good to know. Thank you.
I'll just tell a story about a surrogate who said, you know, he spent all this time sort of structuring a program, and it was a brand new program. He's going to run it as pilot. And he sent out, he said he picked a chunk of his most intractable cases. And he sent him out, and he said he was coming to a meeting and said, I called up my clerk to say, how are we doing? He said, well, Judge, we've sent out 14 and we've gotten through mediation of 11 of them, and we settled 10, but I think we're going to get the 11th one too. And the judges, you know, you were talking, Alon, about a case these were cases that had been on this court's docket for years. And of course, what the judge said is not only did they settle the cases, but in surrogates court, you know, every fight is a subset of some bigger fight. You know, you're not fighting about a tractor, you're fighting about 25 years of resentments and a tractor. And in the mediation, as you folks know, because you're mediators, you can get to the resentments and you can solve the bigger picture in a multi-parted type way, so that they're also finding that the amount of recidivism and further litigation claims by the parties fell off the table after they were able to settle through mediation. So there's a lot of excitement about what's happening.
It's certainly a very welcome trend. Jess, you're up.
Yeah, make this as quick as I can. But I think that we're probably all seeing, I'm seeing on the presumptive mediation, some momentum really starting to build now. And now I think we have to push more I suggest we push more for more resources to build the pool of mediators, to build the skills of mediators, to build the resources for us as mediators. Nassau and Suffolk are carving out more physical space to use for mediation in the courts, in the physical plant of the courts. They're looking for new training programs. And Marilyn and I are constantly having discussions with court staff, whether locally or at state level, on, you know, what more can the Bar Association do to train? I'm kind of like, with what? So we're holding programs that we can. We're working on one now actually for a tort mediation program for both experienced mediators who want to add that to their skill set, and for people who've only had the 24 hours and they want their advanced to be in torts. Maybe they practiced in PI for years and they want to do that. So we're working on these things, but the resources are sorely lacking. So, the more we can direct to that from whatever, whoever can kick in, and including funding to the courts that can be directed to this. The courts tell you they have no money. So, maybe at some point when it's appropriate, we're all on the same page, we try to squeeze the legislature for more funding for that, showing our successes. But I feel more to the point because we started a little while ago with a presumptive mediation discussion, it's not everywhere, because you can't, even when the chief judge says, do this, you say, yes, Your Honor, and we all salute, but it doesn't happen overnight. We are getting there. I'm seeing more cases referred. I'm seeing more people with it on their radar for whom mediation wasn't a thing that they'd heard of it, but they weren't experienced in. We're getting there. And as long as we keep doing this, I think it's really going to keep growing. So we should try to figure out how we can help push it forward even more. And I know that's a very broad and vague statement, but that's what we've been doing locally and State Bar, and I know Elon and NYCLA, and so we're all heading that way in the City Bar. If we keep doing that, it's going to grow, with its own momentum. I'll stop.
Thank you very much, Jess. And just to dovetail off your point, I believe there's now, unless we're going to have some other allocation coming up, but I believe there's now somewhere around the lines of what I've heard from the various people, a $30 million surplus in light of the money from Uncle Cuomo being returned to the budget in light of the judges who are not certified now apparently being allowed to come back. If some of those judges don't come back to their original positions because either they're not interested or they just decide to retire, what else? Is it possible maybe that we could get some sort of reallocation of those resources? Having, whether it's $30 million, even $15 million, having that might be the solution over here. Does anybody have any comments on the possibility of reallocation of money that's coming in now in light of either COVID because of federal, or alternatively because if we have a reallocation from the judges? I saw Laura just raised her hand.
Yeah, I think I have a problem with the whole notion that we're going to inject our compensation right at this moment. I just have I want to be fairly paid. I think Jeff made the point, if you really don't want to volunteer for these panels, that's something you don't have to do. If you're as good a mediator as Jeff is and you can get the independent cases, that's one way. But there is a public need right now. We have a horrible crisis in the court system. We have a backlog. It just doesn't seem to me to be psychologically the right time for us to inject, oh, poor us, into this calculus. I feel like it's really going to be an interference with progress.
But Laura, I wonder if some of that money could be put toward administrative resources.
That I think would be fabulous. And certainly I know like Lisa Denick and Lisa Courtney would lobby for that. And Marilyn's shaking her head. I think everybody would want that more administrative help.
Laura, and Alon, my apologies for jumping in because I know that's not how you're setting this up, but just because Jess and I had a discussion, I think yesterday, I don't remember anymore, with Lisa and with Joel Kulas, and because it has to do with our training, the training programs we're doing, and in talking about the dollars, and we asked if is there money from the state, because up until COVID hit, there was this batch of money that was supposed to be used. And then they actually said that they think there's going to be money. They're trying to do it, but there are funds apparently that will start to become available, which I think is a really positive thing.
I think that when I hear them talk about where their priorities are for spending on ADR, and obviously, one of the things they're worried, they're reserving a lot of concern about is the is what happens with the floods once the moratoriums are lifted in some other contexts. But two areas were that about 2/3 of the jobs that were actually allocated to ADR coordination got filled before the hiring freeze took place, and about 1/3 didn't. And so the filling those slots is a big piece. And the CDRCs, which are such important contributors to the small dispute resolutions in all kinds of ways, and are in place in all 52 counties in New York and play such important ADR roles, experienced about a $2 million loss in funding. And there's, I think, hope that that gets restored because it is part of the chief judge's priorities. But I hope we'll get a piece of it, but there's a lot of competing demands.
Good to know the landscape. Thank you very much. All right, with that, it's 5:26. So if anybody wants to stay on, any further comments, certainly willing to go till 6, as I said in the email. But if not, I want to thank everybody. Thank you for all your varied perspectives. Again, as I said before at the beginning of this whole thing, this is not a black and white issue. The many different shades of gray. You've seen so many different perspectives today. It's been extremely enlightening. And I'm sure, now we have a recording for this. I'm sure that people from OCA, you saw that Glenn Parker was on before. It might have been one or two other people from OCA who were on before. That they'll be viewing this. Obviously I'm going to make it accessible to them so they can see what's going on and see what the perspectives are to get a pulse on everything. But I think the one thing that we all are unified on is to see the growth of ADR throughout New York State in all its forms and all its aspects, so as to just come up with better results for humanity in general, for the people of New York, to have more efficient and streamlined methods of dispute resolution and just better relationships. So I think everybody at least is finding common ground there. And I want to thank everybody for being on this call. This is your last chance. Anybody who hasn't said something before, you want to say something, now's your last chance for this particular meeting. No, going once, going twice. I'm an auctioneer here 3 times. All right. Well,
Thank you, Alon. Thank you very much.
thank
Take
you
care,
very
everyone.
much to everybody.
Well, everyone.
Take care. So
Thanks, everyone.
before everybody goes, but when I do get this up, I'll send out an email to everybody with the YouTube link. It'll be put on my website so you guys can have that. And if anybody wants the actual video file, if you want to use it as part of your bar meetings or what else, I'm certainly willing to give that to people as well. I'll put it onto my Google Drive, just like with all the other documents. In the meantime, I can just tell you, I want to complete the table of the state compensation statute so people would see that. And I think that will just be an excellent resource for everybody's here. But to the extent that anybody wants to contribute to that, I mean, we have Federico from NYCLA working on that, but anybody wants to come in, send me an email about something about the jurisdictions that I haven't picked up on. I certainly haven't gotten to every single program and every single statute, even in the ones that I've put on the chart so far. So if you have a comment or what else that you want to be put into the chart, either put it in directly. That document is hot. If you go to the link there that I've put out, the petition update, or just check the emails. There's also an email for the statutes, the table of statutes. You could put in whatever comments you want there. Just please don't erase something unless you know that it's for a fact to be 100% inaccurate. That's the only thing I ask. Other than that, that table is hot. You can edit it as well. Hopefully it'll be a great resource for the people of New York. And thanks again, everybody, for staying so long. Have a great night, and I'll be in touch.
Thank you.
Good night.
Thanks a lot.
Good night.
Thank you.
Good night.
Thanks, Alon, for putting it together.
You're very welcome.